SJC-12866, Commonwealth v. Deron and Silvelo.
Good morning.
Good morning.
Michelle Dame for Deron Silvelo. May it please the court. Today I am asking that you reverse Mr. Silvelo's firearms convictions. I will first address issue 1 in my brief about the jury not being instructed on an essential element of carrying a loaded firearm without a license. That being that the jury had to find beyond a reasonable doubt that Mr. Silvelo knew the firearm that he was convicted of possessing contained ammunition. Since there was no objection to the jury instructions as they were given, and Mr. Silvelo did not specifically request that this instruction be given, this court must review for a substantial risk of a miscarriage of justice. The court has found that even when an essential element is omitted from a jury instruction, that a substantial risk of a miscarriage of justice can occur even when it has not been requested by trial counsel, even when it does not relate to a defense that's relied upon by the defendant at trial, and even when there is actually sufficient evidence to find that essential element beyond a reasonable doubt. The court has said that the quintessential substantial risk of a miscarriage of justice is when the jury might convict a defendant without finding one of the essential elements beyond a reasonable doubt.
May I ask you, I have a major concern in this area with regard to the jury instructions and objections and error, and that is, if we go with your interpretation, would we not be rendering all errors in jury instructions to be structural errors of sort?
It's not, because there are times that the court has said that a substantial risk must be found unless the element that's at issue, and here that's knowledge of the firearm being loaded.
There's also the carve-out of cases that talk about a fact being, or an element being ineluctably inferred,
yes,
whatever they
then that would be if the jury would be required to find the missing element.
Isn't that, here, they apparently believe that the officer's testimony, and apparently there's no way to not see the bullets. So why would that not meet that criteria?
I think it would have been. I do think the fact that this was a revolver and the fact that if you credit the officer's testimony that Mr. Silvelo had it on his person and that dropped it underneath the seat of the vehicle, I think those two facts are certainly sufficient to find that he knew the firearm was loaded, but I don't think it would require it. The appeals court seems to create this sort of presumption that any time that someone is in actual possession of a revolver, that they must find knowledge. And the courts that talk about, and the cases that have talked about a revolver, cases that have talked about when a firearm is in someone's actual possession, do not say that a jury must find knowledge. It just says that a reasonable jury could find knowledge, and that knowledge may be inferred from those facts.
Isn't there a big distinction between those cases that deal with sufficiency of evidence and the error that you're arguing here, which is the lack of a jury instruction on an element?
I think it is. I think actually the substantial risk of a miscarriage of justice standard is actually an easier standard for the Commonwealth to be able to get over. The substantial risk asks if a reasonable jury could find knowledge. What must be decided here is whether a jury would have been required to find knowledge, which I think is a higher.
But they're different burdens, right? Because if it's a sufficiency issue, it's the light most favorable to the Commonwealth.
But
the error here we look at is to whether or not there was overwhelming evidence, like a failure to instruct on public way in a drunk driving case when there's a chase down Route 3, something like that, right?
yes, and I mean here, it's certainly, what the jury heard was that Mr. Silvelo was one of a number of passengers in a car that was stopped. It certainly would have been plausible for the jury to find that perhaps one of these other passengers in the car had handed him up the firearm at the last minute, which would have been in the situation where he wouldn't have had the opportunity, the chance to actually inspect that firearm to see if it was loaded. So the jury here didn't hear about any the how and the when that he came into possession of this gun.
Are you conceding the fact that the ammunition is visible in this revolver?
I'm not sure if it actually was that clear. I know it did say that you could believe there was testimony that there was some ammunition in the chamber in the way the revolver was, but I don't know if looking at it from every angle you would have been able to see if there was actually ammunition.
The jury had the revolver?
I think it was introduced as an exhibit, and
So they could have seen for themselves, in other words.
I assume that the jury did not get it loaded as it was.
not loaded as it was, I apologize, no.
Here, the testimony is that the police officer had to open it to see if it was loaded.
Yes.
So wouldn't that imply that you had to do something with it to see if it was
It,
loaded?
it would imply that, yes. Again, I'm not sure if it would have been clear from every angle, depending on how he actually was handed that firearm, whether he would have been able to.
So, counsel, I'm very sympathetic to your argument. I understand it. But my one other concern I have is, doesn't this push the limits of logic and rationality to say, to require proof like this, or to require the instruction in a situation where they found he was in possession? Anybody with isn't it just a logic issue here?
It maybe would have been logical, would have been reasonable for the jury to find this, but doesn't mean they would have come necessarily to that same conclusion. They didn't find that he was in possession of ammunition. They found he was in possession of that firearm, that he had the knowledge, ability, and intention to exercise dominion and control. Now, the possession of ammunition charge, if that hadn't been null pros prior to trial, and the jury had convicted him of that, then we could be assured that they had actually found that he knew about that ammunition, because they would have found that he knew about the ammunition if they convicted him of possession. But here we don't have that, only that he was in possession of the firearm. So while, again, the facts, the evidence were certainly sufficient for it, the court's job here is not to sit as a second jury and to weigh that evidence and say, well, a reasonable jury would have done this, it would have been logical. The court needs to decide whether or not they would have been required to find that.
The Commonwealth sort of suggests, they use the word inference, but they're almost suggesting that there's a rebuttable presumption that people do not put guns that they have outside their house, not being stored, that they take a gun, they put it in their waistband or in their pocket without wanting to know if it's loaded or not, because the purpose of a gun is to shoot bullets, and you want to know whether that purpose can be realized. And that sort of permeates their argument.
I think that's a reasonable and logical assumption to make, but people do unreasonable and illogical things all the time. So there's certainly, I'm sure, a number of people who would just grab a firearm without knowing that it was loaded. And one of the cases that I cite to is the Commonwealth versus Ascende case in the appeals court, and that said that while it was reasonable for the jury to find that a defendant would know that the firearm was loaded because it was in his waistband, that the jury was not required to find that he was aware to do so. They simply said that it was a reasonable and logical argument, again, to make.
So if I can turn you to the issue of the search.
Yes.
Why could the officer not conduct just a regular automobile search if he had seen what he believes to be a firearm, that the person was concealing? Why can he not infer that he's hiding it because he is not authorized to possess a firearm, and then simply search it pursuant to a traditional automobile search?
Automobile search. I think he would have had to have probable cause to find that was an illegal firearm in the car, and not, based on something that Mr. Silvelo did not have a license for. The argument could have been made that Mr. Silvelo was disposing a gun because of perhaps the warrants and didn't want to be found with whether or not it was a validly licensed gun, due to the fact that he had these outstanding warrants, and that could have been the situation. I think, again, we didn't necessarily have, at that point, while it may have looked like it was a weapon, looked like it was a firearm, at that point, the trooper did not know that it was a firearm in that car.
Under the Alvarado-type standard that you're alluding to, wouldn't the inference be, we're just dealing with probable cause, right? Wouldn't it be that if he was a lawful firearm owner, he says, I've got a license to carry, here it is, as opposed to ditching it when the trooper approaches?
And I think, again, he said that it resembled a firearm. This wasn't a situation where you could clearly see the handle of a firearm protruding from underneath the seat. I think there was some issue with what had actually been
But he
dropped.
called for backup immediately, and he probably did something that was very safe. He went back to the cruiser because there's kids in the car and other people, and rather than being a cowboy, he said, let's de-escalate, and then call for backup immediately, saying there's a firearm in the car, right? And I guess more problematic for you is the judge made that finding,
Is what?
the judge made the finding below,
Yes.
right?
I still think it not necessarily was a probable cause search. Again, the judge that upheld the search found it based on a protective search or a search incident to arrest, which I don't think either one of those situations did apply here, given the fact that Mr. Silvelo was already not going to be returning to that car and under arrest for the warrants.
It still could have been a protective search in that the officer shouldn't just say, there's an illegal firearm with 2 other adults in the car. I guess I'll just turn my back to it.
I think at the point that he searched, he didn't know that it was an illegal firearm in the car.
Oh, okay.
That was just something that,
So we
an
tell
assumption
police
that.
officers, if they see a gun, just don't worry about it?
I know that is difficult to comprehend, but I would just point to the Commonwealth versus Johnson case in the appeals court, and they said even where there were some concerns with the driver who had the outstanding warrants and some concerns that there may have been a weapon in the car, because the passenger, who was the only one that was remaining in the car, that there weren't any safety concerns pertaining to her, and she could remove the vehicle from the scene, that they could not search the car for protective reasons, because the only person who the officer felt was a risk had already been, well, in that case, what was the potential that he could be under arrest for the warrants hadn't even been decided in this case. In Mr. Silvelo's case, he actually was under arrest at the time that car was searched, so there was absolutely no chance that he was going to be returning to the vehicle. We're only left with the passengers, and then we have to ask whether there were any reasonable safety concerns pertaining to any passenger in that car. And based on what the officer testified to, there would have been no reason for him to have concerns that those passengers were going to use that weapon against him. In fact, they were all allowed to leave the scene even when the firearm was found. I think further supporting the fact that the officer didn't have any concerns about any of the other passengers in the car.
So refresh my memory, he made the stop, then he learned that the passenger had a warrant outstanding, is that
He
correct?
did, yeah, because Mr. Silvelo was not wearing a seatbelt. He asked him for identification. That was how he learned his information, ran back to the cruiser, ran that information through, found out he had warrants, came back to the car, removed him from the vehicle right away, arrested him. I think he was still not actually in the cruiser, but towards the back of the cruiser, and then he went back and searched the vehicle.
So if he had decided that he was going to, at the very time that he made the arrest, seize the gun, you would say that is within Chapter 276, Section 1, because it's the removal of the weapon that the arrestee might use to resist arrest or affect his escape. If he had done it, if he had decided to do it right then,
Because it has to be when the arrestee is still within reaching distance of the vehicle. So if he hadn't been moved to the back, not within reaching distance, perhaps it could have been done as incident to arrest.
so since he could have done it incident to arrest, but chose, as Justice Gaziano described, prudentially to do it in a way that he thought was safer, why should we punish him? Or why should we not allow it to be done this way?
The search incident to arrest, I believe, has to be done contemporaneous at the time that the arrest has actually.
Right, no, I
Contemporaneous.
understand, but the question is, you mean, I think it's pretty clear that if he had decided to grab for the gun at the same time that when he was alone, as he tried to arrest this individual, that would be okay. But instead, he thought it was more prudent and safer to pull the individual from the car, get back up, and then go back in and do that search, which seems to be arguably a sensible thing to do. So why should the law prohibit him from doing something which ultimately is more sensible and require him to do the thing which is more dangerous?
Well, the purpose of allowing them to search when the arrestee is still within reaching distance of the vehicle is to allow it so they don't get those means to escape. The time he's no longer near the car, there's no chance that he's going to be able to get into that car to remove the weapon. So the purpose of being able to search the car incident to arrest for that reason no longer exists. And if any time the police remove a suspect from the vehicle, bring him somewhere else, and then go back to search the car, and that was always allowed as a search incident to arrest, because they could have done it at the time they removed him and just chose not to, then that really takes away, really just sort of gets rid of that requirement in order for it to be
The
incident to
way,
arrest.
although not relied upon by the judge below, it's still the first premise the chief brought up is there's still probable cause, there's still a motor vehicle, and there's an automobile exception, correct?
There is, if the court was to find that there was probable cause to believe that an unlicensed firearm was in that vehicle, then that would be an automobile search.
Okay, thank you.
Thank you.
Well, go ahead, never mind. Never mind.
Sorry,
No, never
there's
mind.
still time.
Well, no, that's all right.
Okay,
I'll ask the Commonwealth.
okay. Ms. Sullivan.
Good morning, Catherine Sullivan for the Commonwealth this morning. The primary issue before the court today on the defendant's FAR application is whether the result, whether the outcome in this case would have been the same had the instruction been correct. In other words, if the judge had instructed the jury that they were required to find that the defendant knew that the firearm was loaded, whether they still would have convicted him on that charge.
I'm not getting the premise that it was visible based upon what you cite in the transcript.
Okay, and so
The bullets were visible. Clearly
right,
visible.
so if you look at page 23 of my brief, it talks about Trooper Schumacher's testimony.
So
And
I've got page 68 through 70, and he basically says, you flipped open the revolver portion, correct? And that's how he saw it was loaded on page 70.
he says,
He had to open it to make sure it was loaded.
page 69, he says, I believe there were four bullets. There were bullets in the magazine well.
Right?
You actually flipped over, correct. And then I have page 73. There were 4 rounds in the revolver.
Right.
I guess, so my understanding was,
It's the visible part, and then you look at the ballistician, and on volume 2, pages 134 to 135, all he says is a revolver, and you put bullets in the spinny thing, and it fires, right, in the cylinder.
right, and so he's testifying as to how it's loaded, right?
Right. But
There's,
where did he get from all of that it was clearly visible?
he says that there were bullets in the magazine well, which he flipped over to reveal contained 4 rounds.
Right.
So he saw that when he first
That flipped
gets the gun,
flipped is
he
the verb,
sees it.
right?
I'm not sure that,
He had to open it to see if it was loaded. That means when it's closed, he couldn't see that it was loaded. Well, put it this way, you need overwhelming evidence.
right, and
And
so.
that's your problem with these transcript sites, the lack of overwhelming evidence.
Correct.
Maybe you'd win, and I'm not saying you would, but maybe you'd win if it was a light most favorable and it was on the other
Okay,
part.
so we have indisputed evidence that it's a revolver,
Right.
right? And we have indisputed evidence that the jury had the bullets and the revolver.
Okay.
And we have undisputed evidence from the trooper that there were 4 bullets in the well,
Right.
right? So the jury then has
Which,
theoretically, the 4 bullets and the gun, probably
someti-
not
but
together.
As you know, sometimes with revolvers, the bullets are visible, sometimes they're not.
Correct.
That's your problem.
In this case, the bullets were visible. There are 4 out of the 5 bullets were in the revolver, and the jury could see that. And the appeal,
I won't belabor this, but I'm still not getting your premise that they were clearly visible because nothing I've read says that they were visible.
if you had the revolver and the bullets and the 4 bullets in the revolver, you would see that they were visible,
The jury
as the
had-
How do we
jury
know
did.
that? How do we know that? Where's that statement in the record?
It's what the jury could conclude irrefutably from the evidence.
But they didn't have
So
the
the
bullets in
transcript, excuse me one sec, sorry, go ahead.
So just to clarify, did they have the bullets inside the revolver? I was told that they weren't.
They had the revolver, and the judge said, if you want the bullets, we will give them to you. When you look at the revolver, you can see from looking at it, as the appeals court justices did, which we know because this is not in the record. However, the clerk from the appeals court requested the exhibit be transmitted to them
Why didn't you tell us that in your brief?
because it was not reflected, it was not part of the trial testimony, and I didn't feel comfortable putting something that wasn't in the record, but the exhibits are certainly reflected in the record.
We'd have to ask for the firearm.
And the bullets.
And the bullets, in order to see for yourself. Last time I was here, I was criticized for talking about something that wasn't in the record, but in this case, the jury had the bullets and the revolver. The appeals court justices requested both.
But they didn't have the bullets in the revolver. They didn't have the bullets in the revolver.
You don't need it either way.
You don't need the bullets.
You can see that if the chambers are visible from the outside.
Correct, and in this case, it was a revolver with 5 slots, and 4 were in the
by the way-
Is there
revolver.
testimony to that effect?
Yes,
Okay, where's that?
Where's that?
it's that Trooper Schumacher flipped it over to reveal 4 bullets, so.
Yes, but was there testimony that the jury heard that with a revolver, you can tell that it's loaded just by looking at it
From the outside.
from the outside without flipping it over? I mean, that's the whole
Trooper
premise.
McCarthy described how a revolver would be fired
Okay,
and how one loaded it.
Okay.
And how it operated.
see.
And Trooper Cody also
I don't
did.
know a whole lot about firearms, so the jury may or may not, I don't know. But I don't know that I would know whether a revolver is loaded unless somebody told me, you can see when you look at a revolver that it's loaded, when it's loaded.
Right,
So-
and so we didn't have just Trooper Schumacher's testimony, we also had 2 ballisticians testify during trial.
But
And
just show me
so,
where in the transcript they said you can see that a revolver is loaded by just looking at it.
he testified so Trooper McCarthy, on pages 121 to 123, described how you load a revolver and how it's loaded, and then Trooper Cody described how it's fired and that he fired it. So he described its operability.
But isn't that I mean, you could do the same for the other type of gun, right? An automatic. You could give that testimony, but you can't see bullets in an automatic weapon.
Well, that's because the bullets are enclosed and not visible.
But that's my point. There's no testimony here saying that you can see from looking at the outside of a revolver that the bullets are in there. And that, I'm just saying as a layperson, unless somebody says that, we can't just infer it.
Right, and I take your argument to be, and I perhaps disagree, because he says he had to open it to see if it was loaded. So I think there's an action that had to be done. But what you're telling us, because it is part of the record in that it was an exhibit,
That's
that
right.
if we were smart enough to get the revolver, we would see for ourselves.
Well, I would recommend
Okay.
getting the revolver, if that's your crucial question,
and
if
to
that's
be
your concern.
Right, and to be fair, and it's apparent, but I'll just try to be transparent about this. This wasn't an issue at all
Correct.
before Brown. So we're making this up because the lawyers and the judge and nobody else knew this was coming down the pike.
Right, and the prosecutor couldn't have known.
Right, so
and,
that's,
You know,
But what inference is permissible from the fact that you at one point had charged him with possession of ammunition, then I assume you get back the report, the fingerprint report, and you don't have any fingerprints on the bullets, and then you decide that you're going to no pros that because you don't think you can prove beyond a reasonable doubt that he knew that he was in possession of the bullets.
yeah, and I'm not sure that was the belief going into the decision to dismiss
But
that charge.
if you're
but-
right, there would have been no good reason to dismiss that charge, because you would have said it is ineluctable, even
Right.
without the fingerprints, that the gun was loaded, because that was apparent, but yet you chose to dismiss, not you, but the trial attorney chose to no pros that on the morning of trial, I guess.
Right, so if I had $1 for every time a district court ADA did something that didn't help me, you know, I
Well,
wouldn't
I
have to be
understand,
here.
I understand,
So-
but
So there's that.
what do we do with that? Because one would think that the district court ADA no prossed it because there was a problem of proof when he or she couldn't prove that there were the defendant's fingerprints on the ammo.
I'm not sure why he dismissed it, and maybe he thought it would end up being something duplicative or, duplicative charge, or maybe he was concerned. I'm not sure, but I don't think that we could speculate, and I don't think it's a fair inference to conclude that from
Is it
the dismissal.
duplicative?
He can be
sorry?
sentenced, right? So he could have
couldn't
just,
be
I don't want to
sentenced.
confuse the jury. I've got 2 charges. I'm just going to go with 1.
Right, and so I want to go with,
Can you
can I ask-
address?
No, go ahead.
Is it accurate that the defense at trial was lack of knowledge of the fire, that the defendant didn't know that the firearm was there?
Correct.
So how does that affect this bullet analysis?
it doesn't at all. It's not an issue, and to Justice Gaziano's point, it wasn't raised ever, and at any point, and we've been through these briefings several times.
So can you, assuming Brown applies then, as everybody seems to, can you address this issue that was articulated about a substantial risk as having to be something of substantial weight, or I forget the language the judge, genuine substance. Substantial risk should have genuine substance to it. How does that work with this problem we've got here?
So I don't think there's a doubt, and I don't think there's any confusion that substantial risk requires a greater showing than sufficiency, right? And so we have a lot of cases following Brown that focus on sufficiency. So this is sort of a uniquely positioned issue. But in this case, I think the appeals court majority had it right, that the visibly, self-evidently loaded gun on the defendant's person provided strong enough, whether that means ineluctably, inferably, is something that this court can decide, but strong enough to result in the absence of prejudice to the defendant from that missing instruction. I think that's the Commonwealth's position. That seems to be the position of the majority in Silvelo. And so while there is some attractiveness to Justice Shin's concerns about the juries needing to weigh in on every element, there just is a long series of decisions in this court where you decide in the absence of an instruction on an element.
The judge could forget to instruct on dangerous weapon, and there could be a shoot-in, for example. Or,
Yeah, I mean-
Or it could be a drunk driving case, I said before, where there's a chase down a municipal highway,
Right. And so that's why
right?
this court does it all the time. The appeals court does it a substantial amount of time also. The concern here really is whether a visibly apparently loaded gun, coupled with it being on his person, means the jury would have ineluctably inferred he knew it was loaded.
You agree, looking at the transcript, taking into account Justice Gaziano's questions, you agree that we can't cull from the transcripts that they were visibly obvious, that the ammunition was visibly obvious in the revolver, and that in order to see what the jury would have been on that, we'd need to have the bullets or at least have the revolver. Do you agree with that?
I think it would be helpful to have the revolver.
But I'm sort of asking you if you agree. Justice Gaziano points to the transcripts. I turn the pages, and it says what it says, and it doesn't seem like from the 4 corners of the transcript you can come to the conclusion that the person holding the revolver would inevitably be able to see the bullets.
I don't think you could necessarily rely on this 100%, and certainly when you see the revolver, you can. But
What are
there
we
are
gonna-
several cases that talk about just the nature of a revolver, and that the bullets, whether it's loaded, is self-evident from its appearance. And they compare that to a pistol or another gun where the magazine is.
I
But
don't want to belabor this, but there
Okay.
are revolvers where you can't see, and it'll be the same, as in Brown, it'd be the same as if it was in a semi-automatic magazine, right?
Okay, and so that's a distinction that I'm not aware exists in the case law, and certainly I haven't found it in the,
It just goes to whether or not someone knows something. That's not magic, right? So,
right, like if it's visible and it's apparent, it's self-evident, then they know.
I mean, like Justice Budd, I'm not going to, have seen too many revolvers. So when I look at that, when that revolver shows up, why am I going to know that bullet is visible? Give me a heads up of what I'm going to see.
So this was the first time that I had held a gun, looked at a gun.
Right.
I went to the Lawrence District Court and saw the gun. And it's the gun that I arranged with the clerk to send up to the appeals court, and now it's back at the Lawrence District Court. When you look at it, the barrel is about this long, and here at the
As
end of
Justice
the
Gaziano
handle,
says, the spinny thing, right?
I guess the spinning, I didn't spin.
we'll call it a cylinder for
I didn't
simplicity's
spin
sake.
it. I didn't spin it. I didn't, I kind of looked at it like this. You can see the metal ends of the bullets by looking at the gun. Arguably, if there were one bullet, I will say you could not tell because the cylinder twirly thing, that bullet is loaded and ready to go.
Right.
Or I shouldn't say loaded, that bullet is ready to go. But here, if there was more than one bullet, you could tell from just looking at it, you could see the ends of the bullets in.
That changes the rules of Russian roulette, doesn't it?
Well, there was some discussion about that at my office.
But
I didn't-
the jury would not have been allowed, I hope, to have both the gun and the bullets at the same time.
Correct, and they didn't, and the judge said, if you want the bullets, I'll send them in separately, we don't send them together, that's in the record. But from looking at the revolver, even if you look at it, you can see the 4 holes for the bullets, the cylinders.
So we'll have to evaluate it based solely on the gun, because the jury never had both. The jury could not have put the bullets in the gun to say, let's see if you can see it, if it's loaded.
That's right, and there's no doubt that you can tell the bullets are in the twirly thing. I'm not going to stop. Yeah, so I would encourage the court to get the exhibit if that's the sticking point. At the end of the day, certainly the defendant did not focus on that. He didn't
Can I ask
dispute it.
Justice Lowy's question? Say you lose on this. Say when we look at the bullets, it doesn't, again, we're looking at the cylinder without the bullets, but say we don't get there. Can we get there with the fact that the guy is driving with, how old are these children in the car? They're how old?
There were infants on laps and teenagers in the back seat.
So can we get to there without this, meaning the gun's there, he's driving around with children and teenagers? Can we infer, say the visibility doesn't work?
I don't think that you can get there with
You
knowledge
lose.
that it was loaded.
So you lose unless we can see the bullets.
I think that's the whole point of the case, is that this is a revolver loaded, and it was self-evidently loaded, and that's how he knew.
Okay, thank you.
I'll rest on my brief and the appeals court opinion for the remainder of the arguments. Thank you.
Is this during daytime? Is this during daytime? What's the lighting conditions?